My name is Dr. Ben Pontin. I'm the Director of the Environmental Law Research Unit here in the Law School, and I'm here to talk about a research project that's been undertaken over the past 5 years into the practical impact of common law in relation to the environment. The project has involved many dozens of students over this period, looking at the context of leading common law actions relating to environmental pollution over the past 150 years, beginning with tipping in the 1860s and coming forward to the most recent case, Halsey and Esso Petroleum. Involving students in the research underpinning a study of the context of the common law is rewarding, also quite necessary, because the amount of time it spends looking beyond the reported case law into scenarios concerning what motivated litigants, what litigation achieved in practice, is something that's beyond the work of even a small team of people. So to have, in effect, a group of over 100 students helping with this research has been invaluable. The case study that the students most enjoyed doing was probably the first, the case of tipping. Students enjoyed looking at what motivated William Whittaker Tipping to sue St Helens Copper Smelting Company, what motivated the company to defend these proceedings. They enjoyed looking at what the impact of the injunction tipping was awarded, what impact that had on the local environment. And they enjoyed visiting the site of the dispute, even if that meant sitting on an embankment or viewing from the embankment of the M58, the old Bold Hall estate that Tipping was defending. The case that, for me, has been the most interesting and complex involves Manchester Corporation and Farnworth. Manchester Corporation were municipal owners of Britain's first superpower station in Old Trafford, Manchester. And they were sued by a tenant farmer, a yearly tenant farmer, Arthur Farnworth. On the face of it, the law report suggests that this case was a success. Farnworth was awarded an injunction, and commentators describe this as an example of the common law working to the heart or the height of its potential as an environmental tool. But my students have discovered that the case did not quite have an environmentally beneficial impact, in the sense that Farnworth, on receiving the injunction, found that his tenancy was precarious. There was a scope for the defendants buying the interest in land, stepping into the shoes of being a landlord, and every prospect that Farnworth would be given notice. So Farnworth voluntarily agreed to relinquish his tenancy for a sum of money and to find a farm that was not polluted, about 20, 30 miles away. What's problematic about this case is that the corporation, Manchester Corporation, had invented what would have been the world's first system of flue gas desulfurization, mitigating acid rain from power stations. But the cost of installing that was a factor, and of maintaining that, running that on a day-to-day basis, considered prohibitive, or at least it was more attractive to the corporation to buy out Farnworth's interest, and that's what the corporation did. My students most recently have discovered what happened to Farnworth when he moved on to a new farm, and it was a tragic ending. My students did wonder whether there was a connection between Farnworth's death shortly after the settlement and the settlement itself, but it's not clear that there was. The results of the case studies into numerous common law actions involving my students are to be published later on next year, and it's hopefully going to draw attention to the help and assistance that undergraduate students can provide as original scholars working alongside academics to do things, to explore aspects of the context of cases that it would take probably far too long for academics working on their own on their own to achieve.